everybody, and welcome to this episode of John's Rants. I'm John Giardinelli. I am the association's attorney, and I was just talking to Lori Smith, who is your professional standards manager, and I told her that I had another subject ready to go, and then I've had a few phone calls over the last couple of days with some brokers about some things that are happening in the marketplace, and I literally rewrote everything this morning, so this may be a little disjointed because I haven't had a chance to polish it, but I wanted to get this information out to you because I believe we're going to start seeing some lawsuits, and we already have a problem. So just a couple of things on, and so I've entitled this one "Red Flags," and I'm hoping that you are not experiencing any of these things. But if you are, just be aware of a couple of factors and some things just to keep yourself safe and careful. CAR recently announced, as part of the whole insurance issue, that litigation against realtors and arising out of the real estate transaction document is up over 9%. That's a huge jump year to year. Maybe even more significantly than that is that mediations are up 29%. Now, you have a mandatory mediation clause in your RPA, as well as other related transactional documents. So a lot of people will file mediations before they file lawsuits. That's significant because that means that we're starting to see claims that arose during the super hard market regarding non-contingent offers, escalation clauses, overpaying, and all of that. If it's true that about 80% of cases settle during mediation, and I don't know if that's going to stay the same, but assuming that that figure holds steady, and it hopefully will, that means that 20% of those mediation cases are going to end up in some form of litigation, whether it be arbitration or actual court filings. So that's a huge issue, particularly when you look at the insurance crisis that's going on in California and realize that E&O insurance is getting very expensive. Many big brokerages are starting to increase their deductibles significantly as small offices get hit with increases in their premiums. They may be forced to self-insure at a higher level. And at some juncture, like what happened back in the 1970s, a long time ago, I understand, where insurance companies stopped writing E&O coverage in California, and that created all kinds of problems. So what are the red flags or problems that we're seeing? First on the hit parade is failure to cooperate. This society right now is very, very harsh. Lots of people are writing about it. We're not nice to each other. We're divided politically. We're divided by lots of different factors. Our politicians are doing everything they can to keep us divided. And as a result, things are harsh. People are rude. They don't return phone calls. They don't return emails. Lori tells me that issues regarding having property available for showing, issues regarding returning phone calls of other brokers, issues like that are really a problem. And so at a time when organized real estate needs to do a much better job of putting forth its best face, these kinds of issues are very, very problematic. They're going to lead to litigation. People already have low opinions of lots of realtors, and that needs to be fixed. And those realtors that are engaging in this rude, caustic, uncooperative behavior are the enemy and not our friends. Failure to cooperate could lead to many bad things. Potentially, it's a violations of Article 1, the duty to put your client's interest first. If you're not cooperating because you're lazy, because you're rude, you're not putting your client's interest first, because your client's interests are to buy or sell a house, and you're not helping. It could be a violation of Article 3, which is specifically the duty to cooperate, to provide information in a timely manner, to provide and make houses available for showings in a timely manner, and all those kinds of things. Could be a violation of Article 11, the duty to be competent. The failure to cooperate with another realtor is not competent. You are being incompetent. You are not living up to the standards that have been imposed on you by your license and the oaths you took as a realtor. Failing to put things in writing is a violation of Article 9, and so forth. It could lead to significant fines at either the association or at the multiple listing service. Fines at the association for violations of the Code of Ethics could be as high as $15,000. Violations at the MLS can be $2,500 or more. So again, you look at those kinds of issues, you think to yourself, if people start reporting these things, as they are doing, fines are going to start getting issued, and people are going to start writing checks for their bad behavior. More importantly, however, is if you damage a client, you could end up paying significant civil penalties, damages, attorney's fees, those kinds of things, mediation fees, arbitration fees, jury fees, all of that. And if you are reported to the Department of Real Estate and you damage in some manner your client's best interest, you could end up with an accusation issued by the Department of Real Estate. All good reasons to cooperate with each other. When a consumer hires a realtor to list their property or to help them find a property, they are doing so for their own best interest. They have a house to sell, they have a property to lease, they want to purchase a house perhaps in a better or newer area. And they don't need to have realtors who don't cooperate with them or other realtors. So stop being rude. I was told by a very, very fine realtor just this morning that they're starting to see non-contingent offers again. I thought and hoped that would be going away. If you are considering writing a non-contingent offer in order to jump to the front of the line, remember, there's nothing illegal about it, but you need to be familiar with the rules of the game. It could be an ethical problem. It could be a contractual issue. Your client could end up damaged financially. So the first thing you need to do is make sure you advise your client on the pitfalls of non-contingent offers. Buying a house without adequately doing investigations, buying a house without making sure it will properly appraise, buying a house without making sure that other factors have been properly considered. So you need to advise your client. You need to also make sure your client understands that if they put up a deposit and put money into escrow for liquidated damages and end up canceling without any contingencies to protect that deposit, the buyer could end up losing their deposit. Sellers need to be reminded that in order to protect that deposit, so that if they do want to claim it, they'll be able to, that they need, even if there are no contingencies, to make sure that their transfer disclosure statement is done properly. As you know, in June, they changed the TDS, so now you do one for each unit. If it's a triplex, for example, you do 3 separate TDSs for each unit. And so all of those things need to be done. Now, CAR has an excellent quick guide. You go to car.org, type in quick guides, and you will get a list of the quick guides. If you want to be very specific, type in non-contingent offers, and you will get the quick guide on non-contingent offers. And it gives you a lot of good information about protecting your client's deposit, about what to do in order to make a proper non-contingent offer, and then of course to actually do it correctly so that all parties are protected as best as possible. Also, the seller needs to be reminded that non-contingent offers oftentimes doesn't mean that there's not going to be an inspection. It's just not a contingency. And that if something comes up and there are problems, the escrow may not close. So you got to be careful about that. I've been told that a lot of, because of the market, because of the lack of inventory, because of the need to make a living, a lot of brokers are cutting some corners, whether it be by overlooking certain inspections or whatever it is. Again, making sure that your client doesn't buy a house without knowledge, at least the kind of knowledge that's required in California, to make sure that the property is properly inspected and all of that. So remember that you need to be really still cautious. Just because the market is difficult and not the same as it was a year or so ago doesn't absolve you of your obligations to do proper disclosures and to do proper inspections, and at least to advise your client of the pitfalls of doing things incorrectly, and if necessary, sending them to a local real estate lawyer to make sure that they fully understand all the legal and other ramifications of cutting corners. I was also told recently that we're seeing a lot of listing agents not returning signed documents. We're seeing a lot of buyer's agents not returning signed documents, and that's a breach of contract. Contract is very clear that documents need to be returned, fully acknowledged, fully executed to the other side, and failure to do that is a breach of contract. It's a breach of your duty. And if there are damages because somebody didn't get the information or something along those lines, you could be exposing not only your client, but yourself to a significant damage problem. So be careful about that. Remember, there are contractual requirements to return documents as being acknowledged and fully executed, and there are significant statutory and other problems with failing to do so. Talking to a buddy of mine about litigation that could come up out of all this. Obviously, bad house lawsuits and failure to disclose and all those kinds of things, failure to discharge your legal obligations as a realtor, those things are happening. But we're being told that some sellers are trying to cancel transactions. And so again, what are the remedies for all that? Well, one of the things we may start seeing again are our old friend specific performance. Remember, when I enter into a contract with a seller and a buyer, prior to entering into that contract, the seller, subject to certain legal and other restrictions, has most of the power. They can reject offers. They can do a lot of things to not go into contract. But once you enter into a contract for the sale of real estate, you have what the law calls transferred your equitable title. And if a buyer who is in escrow has a proper contract, is paying an amount that is reasonably reasonable to the market value, doesn't have to be exact, doesn't have to be full price, but is at least reasonable, and is performing pursuant to the contract, has a right to demand that that contract be performed by the seller. And once you enter into that escrow, if the seller does anything to cancel improperly, to hinder, or to refuse to close, that seller can face a lawsuit for what is called specific performance. And what happens then is a lawsuit is filed, in the county where the property is located. And it is a request essentially to a judge to please order that the seller be forced to close the deal. If they fail to do that, the court can order someone else to sign the deed as an elixir, which is a term or a legal term. Additionally, the court can order attorney's fees, court costs, other damages such as rental, loss of a favorable rate, all those kinds of things. Once the lawsuit is filed, the buyer then has the right to record a document called lis pendens, which is a Latin term for action pending. It is recorded in the county where the property is located and gives the world notice that I have a claim to that property. And if I get a judgment, the judgment relates back to the day that the lawsuit was filed, and anything done after that date would be subject to my recorded right. Obviously, there could be damages, and if you fail to cooperate or interfere with someone else's contractual rights, there could be arbitration, procuring cause. And again, because there is so much going on in the industry with antitrust lawsuits, NARs being sued, MLSs are being sued, the California legislature is expanding liability and is doing all sorts of things that could end up costing realtors money. It is not the time to misbehave. So be careful out there. And until the next time, I'm John Giardinelli, and I'm signing off for now. But please be careful. If you have questions or you have concerns, let me know. Let Lori know. We'll do the best we can. We're going to be writing up some newsletters pretty soon, and we're going to be doing some programs pretty soon. So again, until we see each other again, John Giardinelli, Association Counsel, signing off for now. Thank you.